Good afternoon. I'm Jessica Berg, one of the interim deans here at Case Western Reserve School of Law. It's my privilege to welcome you here to the inaugural Maxwell J. Mehlman Lecture Series. Max Mehlman is the Arthur E. Peter Silge Professor of Law. He joined the university in 1984 and in 1987 became the director of our Law Medicine Center. He received his JD from Yale Law School. He holds 2 bachelor's degrees, one from Reed College and one from Oxford University, which he attended as a Rhodes Scholar. Prior to joining the faculty, he practiced law with Arnold & Porter, where he specialized in federal regulation of healthcare and medical technology. He's the author of 18 books, over 90 articles and chapters, and in 2013 he was named a Distinguished University Professor, which is our university's highest honor. So I ask you to indulge me for just a moment. Max actually said I couldn't talk about him at all because, of course, he's not giving the talk, but it is the inaugural lecture in his name, and I told him that I was going to ignore that, so you'll give me a moment. Max recruited me here to come to Case, so I have a number of fond memories of working with him. He's guided me through my academic career. He's been a phenomenal mentor, colleague, and friend. He also recruited me for ski patrol, something which did not work out quite as well as either of us had thought, because soon after that I took on the interim position and we've yet to actually ski together on the mountain. So since he has asked for this introduction to be very short, I went around to some of the faculty and staff and asked them to provide me with a word or two that best describes him. And so here are some of the ones that I heard consistently. Innovative, generous, wicked smart, great bow ties, although he decided today he wasn't going to wear one, so I couldn't show it off. A consistently cool guy. Perhaps the best one was people were pretty consistently telling me that he had a great sense of humor and that he really liked cartoons. So in honor of the really liking cartoons, he has a John McPherson cartoon that John created for him. It shows Professor Mehlman with a bunch of little mice going down a ski slope, and the bottom says, through his genetic studies on lab mice, Professor Max Mehlman hoped to greatly improve the downhill skiing abilities of humans. This lecture was made possible by an extraordinarily generous donation by the family of an alumni in the class of 1998. Establishing this named lecture in Max's name, they have asked to remain anonymous, but we thank them very much for enabling us to do this and bring in such phenomenal speakers. It's my very great honor to present Max Mehlman, who introduced today's inaugural Mehlman Lecture.
Thank you very much. It's a great honor. I have been sort of joking about this since the great honor I was informed about it, because I didn't know that you could get a lectureship named after you unless you were either retired or dead. So I keep checking. And the deans tell me I haven't retired yet, and I don't think I've yet passed on. So, but anyway, it is a truly distinct honor, and it was a challenge because how do you create a new lectureship, and what can you do to make it the special event that I think the donors intended it to be? And so I decided that what we would do is have as our speakers distinguished Case Western Reserve University Law School alumni who've made a significant contribution in the field of health law. So each year we will have one of these distinguished individuals, and the first one is someone that I can't think of anyone who better fits that description, Bob Joondeph from Portland, Oregon. Bob epitomizes the values and career objectives of many members of my generation, and indeed our generation, because we're essentially contemporaries. Many of our generation, like Bob, saw the law as a weapon in the world's fight for justice and dedicated their careers to strengthen not really the rule of law, but the rule of just laws. Some of us were able to do that more consistently and more effectively than others, but very few have been able to do that as fully and as meaningfully as Bob has. He graduated from Brown with a degree in history in 1972. He graduated from this institution in 1976. He went on immediately to Oregon, where he was a VISTA volunteer for legal aid in the southern part of the state. afterwards becoming a staff attorney with the Public Defender's Office and with Oregon Legal Services, and then a managing attorney at an organization called the Oregon Advocacy Center. And since 1991, Bob has been the executive director of Disability Rights Oregon, the premier defender of the rights of persons with disabilities in the state. He's frequently sought after as a public speaker, as a source of news insights. He's won numerous awards, including the Oregon State Bar President's Public Service Award in 2006. His talk today, From Repair to Inclusion, Changing Perspectives on Disability and Health Reform. Please join me in welcoming Bob Joondeph.
Hi, everybody. Well, first of all, thank you for being here in this terrible weather. Reminds me of my days in Cleveland. I think I will be able to use this equipment. One thing I want to say is that the reason I'm here is because I received a telephone call from Professor Mehlman, who I was sitting at my desk at work, and he said, "Hi, I'm from Case Western Reserve, and I don't want money." So I didn't hang up, and he proceeded to explain why he was inviting me, and I was totally flabbergasted. I didn't understand that folks who are out on the West Coast were still on the radar screen of folks here in Cleveland. So it was really fantastic and quite an honor to be invited to do this today. So I decided, one of the things that Professor Mehlman said to me was that you can speak on any topic you'd like. And that's a pretty broad request. And so I decided that the best thing to do was to go do some research. And that led me to a paper right here called When Do Healthcare Decisions Discriminate Against People with Disabilities that Professor Mehlman co-authored in 1997. So I thought, well, even though he didn't say it, I might as well just pick up the question and carry it through to today from the perspective that I've had in Oregon as a practitioner in this area, and just and try to get through that in a fairly brief amount of time. So we're going to launch into it. Are we ready? Okay. This is what Professor Mehlman and his co-authors wrote. He talked about the fact that from the perspective of 1997, it's seen that disability rights laws are going to play a greater role in the healthcare arena, and he was absolutely right. One of the things that his paper analyzed was some recent events in Oregon, and what I'm hoping to do is to walk through some of those events, talk about them, talk about how little old me got sucked into those events, and what I, as a practitioner of disability rights, was trying to do in that process. So back in the early 90s, Oregon had a new governor, Governor John Kitzhaber. Governor Kitzhaber is a physician, and his passion is healthcare transformation, healthcare reform. And he decided, once he became governor, that this was going to be the hallmark of his administration. Another thing that had really stamped his experience was sitting in the legislature, because he was in the legislature for many years before, and in fact was Speaker of the House, the Oregon House, before he became governor. And during those times, because of the unique Oregon taxing system, which produces roller coaster budgets, many times the Medicaid program in Oregon was expanding and contracting, expanding and contracting. And when it contracted, people with very serious illnesses and challenges would find that they had no coverage and would come directly to the legislature through a bill or an initiative in an effort to get coverage. And I don't know if anyone here is old enough to remember Queen for a Day, but it was an old television show in which people would get up and tell their stories, and whoever had the saddest story would win the Amana freezer and other kitchen products. And that's what it felt like for him. And so he said, there must be a more rational way to decide what services are going to be covered in our Medicaid plan and what services aren't going to be covered. And so he came up with a concept which was, and sent people off to work on it, which was to create a prioritized list of conditions and services that would be ranked according to their importance, and that Oregon would make its decision about what services to fund by looking at the entire list, looking at the amount of money that was in the state budget and could be matched by the federal government, and then drawing a line. And everything above the line would be covered, and everything below the line would not be covered. And so, after quite a bit of effort, Oregon sent off to a request to CMS to approve a waiver to do just that for part of the Medicaid population. And the administration of George Herbert Walker Bush said no. And the reason that they said no is they said that waiver would violate the Americans with Disabilities Act. Now, the Americans with Disabilities, well, actually, I misspeak. The Rehabilitation Act, actually, which was a predecessor of the ADA, but basically the principles are the same. And and again, this was curious development in that one of my colleagues from Tennessee had brought a case back in the 80s challenging a Medicaid standard in Tennessee that only funded up to 14 days of inpatient services in its plan, and he and others had challenged that limitation, saying that it had a disproportionate impact upon people with disabilities who statistically need inpatient services of greater extent. And that did not succeed before the U.S. Supreme Court. And in essence, that decision in Alexander v. Choate said that disability discrimination policies could apply to things like getting into a doctor's office or having an accessible examining room type of things, but not get into the structure of medical coverage policies. So like a health policy that makes distinctions between people is okay because it's facially neutral, and the Rehab Act did not apply. So everyone was quite surprised by this. It was assumed that this would not be a problem. Also in the paper, Professor Mehlman noted that some of the factors that went into that denial, and very briefly, again, I have a hard time reading and talking at the same time, you'll excuse me. But the federal government said, listen, when you put together this plan, one of the things you did was that you prioritized your conditions and treatments based upon what you felt were outcomes of care that improve the quote-unquote quality of life for the individuals who are receiving the care. And you determined what would be an improved quality of life by going out and asking the public what they felt were important factors of quality of life in order to make your plan responsive to public need. But you know what? We have this law, Rehab Act and the ADA, that say that one of the problems that people with disabilities experience are misperceptions of the quality and value of their lives, and that those misperceptions are irrational and need to be corrected. And so when Oregon was essentially proposing to make decisions about healthcare coverage based upon assessments of quality, that is a violation of the Americans Act. In addition to that, there were certain conditions and treatments that were on that list which were inherently disability conditions rather than health conditions. And the federal government said, look, you can't be prioritizing something like, for example, quote unquote, mental retardation. and balancing it against liver disease, because you're excluding an entire group of people who are defined by a particular disability. So there are some real fundamental problems with that. So Oregon went back to the drawing board. And when it went back to the drawing board, as a disability advocate in Oregon, I and many of my colleagues got pulled in to start looking at what men that would make sense in that situation. By the way, one of the, that term quality of life, I just want to say that even though we fought these battles way back then, you will still hear that phrase used, and you will still see principles being applied in healthcare decision-making and in healthcare coverage decisions. But we don't like that term. And now you know why. At any rate, Oregon finally did, their waiver request was finally approved after a number of changes that certainly brought me into a greater appreciation and greater education around both healthcare coverage, healthcare insurance, and disability law. As I said, there was no health law center here at Case Western Reserve. When I went to law school here back in the early 70s, they must have seen what I was going through and decided they wanted to equip their students better for the challenges that lay ahead. So in Professor Mehlman's paper, he asked some questions. Can treatment be denied if that is considered to be not worth the treatment? Can providers and payers take quality of life into account? No, that they do. And can a payer cover one disabling condition and not others? Well, again, just think about what I said. What we're saying is that what George Herbert Walker Bush in the Clinton administration was said that we don't cover disabling, we cover medical conditions, and there is a distinction. Oh, and I didn't answer the first one, which is not worth it according to who? So I'm going to give you a very quick, because this isn't a long lecture, sense of where disability rights come from and why disability rights are a way of thinking and a way of analyzing things. And I always like to start with Buck versus Bell, because it was written by Oliver Wendell Holmes, who of course we all respect. And he got to rule on a case in which some people with disabilities were challenging mandatory sterilization laws in Virginia. Oregon had mandatory sterilization laws earlier than Virginia even, because Oregon is often in the forefront of science, and eugenics were the science of the day. And so in Oregon, we had a board that was set up to preside over the mandatory sterilization of people. It wasn't just for people with disabilities. It included people with aberrant behavior, people who were considered career criminals, people who were prostitutes, people who had mental illnesses. And the Supreme Court said that's just fine. It is equivalent to, say, putting someone with Ebola in a tent for a couple of weeks. Some people forget that people with disabilities were the first group singled out by the Nazis because they took many things to extreme, and eugenics was one of them, and so about 300,000 people with disabilities were cleared out of institutions in their homes and were the first persons who tested out the gas chambers and other forms of execution. The reason I bring this unsavory past to your attention is that some, in the civil rights arena, some don't or take issue with whether people with disabilities are a discrete and defined minority that experience similar types of disadvantages. And The answer is yes. And these are some striking examples of that, but of course there's many more. So hearken with me as we move through history, as some of the principles that had been developed in the United States and laws that were really designed to deal with returning soldiers from World War I and World War II who suffered war injuries started to get coupled in with folks with pre-existing disabilities into a sense of that this was a discrete minority and that it should have some rights, and it had some very common types of impediments that were placed before them. Advocates arose, and as we moved into the 60s and the civil rights movement, there were many people in the disability community, people who said, you know, the whole structure of thinking about civil rights really applies to us as well. I know that. And so in 1964, with the passage of the Civil Rights Act of 1964, there were people with disabilities who were basically saying, we want some of that. And as they moved forward, they began to strategize as to how they could do a multi-pronged strategy in terms of achieving greater rights. And one was statutory, and one was community organizing, and one had to do with legal advocacy. And so there were a series of cases that made their way to the Supreme Court, testing the bounds of civil rights protections under the Constitution and under some statutory protections as they evolved. City of Claiborne was a very significant case in that development because advocates were looking for recognition that disability was a minority like other minorities that required strict scrutiny under the 14th Amendment. They were not successful. We'll touch upon that in a bit. But there were other cases such as Youngberg versus Romeo, which talked about the rights of people in institutional settings in states, which basically said that people who are involuntarily isolated in state institutions do have the right to safety and the right to at least enough habilitation so as not to be unsafe, but they do not have the right to get better or to services that are good. And then Washington versus Harper had to do with a standard for involuntary medication for people in prison, but has been extended to institutions. Sell versus the United States has to do with rights of people in the criminal justice system when it comes to forced medication to return them to competency to face trial. And I always like to throw in Zinnerman v. Bush because it's one that aggravates all sorts of people because it had to do with a man who voluntarily admitted himself to a mental hospital in Florida and then turned around and sued the hospital for admitting him because he didn't know what he was doing. He was incapable of making decisions when he voluntarily went into the hospital, and the court found that in fact he did have a right to make competent decisions, and that if the state wanted to take away his freedom without his voluntary consent, that it needed to go through a due process procedure before doing that. These are just examples of cases. There are lots of legal cases that we could talk about. Coming back to City of Claiborne for a minute, I think one of the principles about it that's particularly interesting was that the Supreme Court almost grudgingly went through the analysis for strict scrutiny and found that disabilities as an identity met almost all of the prongs for strict scrutiny. But the one that it did not meet was their recognition that this was a group that knew how to advocate for itself, knew how to go to the legislature, knew how to bring lawsuits, and that it was not so disadvantageous to lack political power. And so folks in the disability world said, okay, we're with you. We're going to go try to exert some of that political power. And and so this is just a list of some of the federal laws that were passed over that course of time that provided specific legal rights to people with disabilities for this population. And by people with disabilities, I mean the entire range: physical disabilities, cognitive, perceptual, emotional, psychiatric, the whole range. This is a group of people that in our laws, both and in our statutes and in our court cases, have been recognized as a distinct group having specific civil rights. With me so far? Any corrections? Okay. And again, I've already sort of gone over Alexander v. Choate, but I think that again, one of the principles that was very applicable to the paper that we're discussing was the fact of making a distinction between services that services being accessible to a person with disabilities, as opposed to the structure of a healthcare insurance program, which is a key distinction that we're going to walk through, because think of it as a problem. Now, I've talked about the fact that there's lots of disability advocates out there. They have been told by the Supreme Court, go forth. You guys got the moxie, you got the power, you can deal with this. So disability advocates said, well, gee, we have I'm going to move through quickly here. We have experienced a lot of discrimination in the field of healthcare. It isn't just that we can't get into the doctor's office and there isn't an examining table that I can be seated on. There isn't a I can be weighed on. That because of my doctors don't understand my disability, that they don't even give me examinations, and that the data shows that my healthcare outcomes as a group significantly less than those for people without disabilities. So how are we going to try to tackle that? Well, in the talking about that within the context of the ADA, when the ADA was drafted and enacted, the way that those folks looked at the law was that it was more than just a law that provided certain rights to people with disabilities. It was a revolution. It was designed to fundamentally change the way people in the United States and perhaps the world viewed disability and viewed the essential identity of a person with disability. So its goals were to create equality of opportunity, full participation, and by full participation we mean go everywhere, do everything, have a job, have a house, have a life, to live independently or as independently as possible, and perhaps the big one, to have economic self-sufficiency, so that people who did not have to rely upon public largesse or family largesse could in fact support themselves. And we were talking a little bit earlier, my colleague, about the fact that when I began work in this field, people with cognitive and intellectual disabilities tended to be disabled for life and were in care facilities, either in mental retardation, so-called facilities, group homes. And why? Well, the model back as late as the 1960s was, well, gee, here we have a person who's been born and we have identified this person from birth as having certain deficits in terms of their ability to learn and be self-sufficient in life. So what are we going to do about it? Well, let's take away all education, all training, all dealing in the real world, so that those folks can never develop whatever skills and abilities that they had. So he took people who had disadvantages to begin with and then took away all of the things that we have developed in order to have people develop. One of the things that was very striking to me and touching to me is that there's a film about our large institution in Oregon for folks with intellectual developmental disabilities that, as a result of a lawsuit that I worked on and others, ended up being closed in 2000. But this is a film from the 1950s, and one of the pieces of the film you see the large room, a large room lined with cribs, and there's probably about 20, 25 cribs there, and a nurse walking down the row of cribs and looking at each of the little kids who've been given up by their families because their physician, when they were born or as soon as they were identified as having disabilities, said that you should send the child to the state institution, they'll be taken care of, and forget about that kid and move forward with your life. That was how we did things. So, and when I saw that little chunk of film, I thought, well, you know, think about what we have learned since then about the importance for a baby in developing their abilities by just the touch of a parent, the touch of a mother. What we learned about the importance of hearing words. And you've seen the studies about the more words you hear in your early development stage, the higher your intelligence quotient is. I mean, these just fundamental developmental aids that we have for people, those were all removed from kids. The next part of the film was the kids who were the toddlers, who were all in a room on the floor, some in their own waste, and who were just kind of herded into these rooms. Someone told me that if you happen to live in one of these institutions, there was always a question of violence, because what you learned was that if you had a cot where you slept, that the best way to keep other people from taking your stuff was to whack them. And if you did that enough, then nobody would take your stuff. So I thought, you know, that's exactly what I would have done. So don't get near me. One of the things about the ADA is it's specific in its findings. It specifically finds that the area of health services and access to public services of all sorts, and those would be social services, are areas of ongoing and stubborn discrimination that needed to be addressed. So I'm putting this up on the board. If anybody wants this, I do not copyright these matters. I'm a public servant. I'm happy to make these available. But this is a paper by Bobby Silverstein, who worked for Senator Tom Harkin when the ADA was created, analyzing the background of the ADA. And what he talks about is the ADA, as I've just mentioned, is not only supposed to give people rights, but it's supposed to change the entire way of thinking about disability. The old model being that disability was previously thought as something that needed to be fixed. So if you couldn't walk, we had to try to get some braces so you could walk. If you couldn't see, we needed to replace your eyes. I don't know. We needed to fix those things. But the principle that disability is an immutable part of life. There always have been people with disabilities from the beginning of time. There will always be people with disabilities. And that what we need to do is modify the environment and our services so that they are more accessible to all, as the basic principle of the law. You'll see that policy that Bobby talks about, not only in the ADA, but throughout federal and state legislation. It is embedded in a whole variety of things. So just, if the one takeaway that you bring from this lecture and go back into the snow is this principle. Is that we are now in an era in which our public services, our public money, and our laws are trying to engage and integrate people with disabilities into our culture, into our society as effectively as possible. Supreme Court didn't get it. In 1999 was the year. I don't know what it was about 1999, but this was 2 years after you wrote your paper. So right now, where we're going is we're saying Professor Mehlman and his colleagues could not look out into the future, but he did a really good job in predicting where it was going to go, because this is where it went from when he asked those questions. Those 3 top cases that I cite were cases the Supreme Court narrowed the scope of the ADA. They didn't like the ADA. It's my opinion, but fair one. They made it as limited coverage for the number of people as limited as possible, when it applied as limited as possible, with one exception, which was Olmstead versus LC. And Olmstead versus LC said, in essence, that, gee, there's this portion of the law that says that individuals with disabilities should not be unnecessarily segregated when the state or a government entity provides services to them. Being that, if, gee, a person has a mental illness and says, I need some services, I could get those services from a community mental health center, maybe have some housing assistance, maybe have some supports with my cooking or my living, some job training, or I could go to the state mental hospital. And it's more or less cost neutral if you step back from it, but a state or a local government has decided that everybody has to go get their services in the hospital. A segregated environment being an environment in which everyone there has a disability except the people who are paid to look after them or to provide a level of care. That's what segregation means in this context. And the Supreme Court, maybe because it was governmental services and it didn't touch upon employment, which was always the area where the Supreme Court was most anxious about equal rights for employees, they said, yeah, that's what the law says, and so the 2 women from Georgia who were in the state mental hospital unnecessarily wanted to get services in the community were entitled to them. Otherwise, the state of Georgia would be violating the rights under the ADA. So, however, there was still so now we're starting to move toward the area of, well, these are social services we're talking about, public services. There is an integration mandate. But the ADA, because it was heavily lobbied and so forth, did have an exception for insurance, for private, which said essentially what earlier in Alexander v. Choate, which is that in the structure of a healthcare insurance policy, you can discriminate against people with disabilities if not doing so is going to cost too much. That's my interpretation, but it's a fair enough assessment. I like to take a look at a paper that was written by a professor, Sarah Rosenbaum from American University, because she kind of lays this out very nicely, just what I said. So if you want to read about it, I would go look at that. But what she talks about is the state of the law in 2007. So this is 10 years after Professor Mehlman and his colleagues' work. She said, discrimination laws provide some protection for access to health services, but not for the structure of a discriminatory design of a health care policy. So, never to be deterred, disability advocates said, well, there must be another way to go about doing this. And what I'm going to talk about is how that has happened. And essentially there's 4 ways that at least I've recognized that this particular limitation has been worked on. One is through expansion of the ADA and clarification of its terms, the Affordable Care Act enactment and implementation, state health care reform efforts like Oregon's, which I'm probably not going to have time to go into at length, but this is one of the topics that it's really designed to address. and federal and state insurance coverage mandates. I'm looking at you because you're the one who's going to tell me when I'm out of time. I got 10 minutes. Cool. The Americans with Disabilities Act, Congress came back and revisited it, passed, if ADA didn't have too many A's already, they passed the ADAAA, the ADA Amendments Act, which basically said, and I'm paraphrasing, basically said, you know, Supreme Court, you got it all wrong. We were not passing a law that was designed to be limited to just a tiny little group of people who had the most severe disabilities, and to disallow coverage for anything but the most narrow reading of the law. What we're interested about, and most litigation up until this time was about whether a person has a disability or not have a disability, because good defense attorneys said, well, the Supreme Court said this is a narrow group of people, so we're going to go and litigate whether this bad back is bad enough, whether this head injury is bad enough, that type of thing. And the ADAAA said, we want you to interpret this law as broadly as possible. We're going to provide a very long list of things that we consider to be disabilities, and you should too. And that we want, what we would like is for lawyers and for public services and for and public accommodations to think not in terms of, well, is this person really disabled or not disabled, but think about the accommodation. What type of accommodation might this person need? And I would submit to you all that we all need accommodations. I'm wearing some accommodations up here today just to demonstrate this, but very few of us are perfect. Most of us have most things that are created for a broad group of folks in society understand that everybody's not the same, but there's sort of a generalized way to try to accommodate most people. But there are, each of us in our own way, are going to need some little change in order to use what is made available. And that's the way the court wanted, or the court, I should say, the legislature, the Congress said, you know, this is really what we want you to focus on. And so that's 2008. Some other things happened out my way, out in Oregon, but it was that there was a lot of interest in really tackling the health care problem. And the problem, I would say, is the fact that 18% of the gross national product in the United States is going to healthcare, and then most other most other Western nations spend a lot less on their healthcare as a matter of public expenditure and get a lot better outcomes than we do. That was the problem that was posed. I know that there's some who feel the Affordable Care Act had other devious, there were other devious reasons for it, but basically the question was, can we bend the cost curve of healthcare? And so Oregon, as well as folks on the national level, said, well, let's take a look at where our money is going and how we can save money. And it ended up being very complicated, but essentially one of the areas that was highlighted as a place to save money was for people who have chronic conditions, because people with chronic conditions eat up a lot of medical costs. And if you could address those chronic conditions earlier, in a more integrated community setting, and allow a person to sustain community integration, sustain economic activity, maximize the community supports, be able, say, on their own to go to the grocery store rather than having to have somebody else who's hired to go to the grocery store for them. If they need toileting or help preparing foods, to have somebody in the house to help them with that rather than having them go into a nursing home. we're going to save some money. And, you know, the other thing that coincides with that is the fact that people would rather stay in their homes. They'd rather not be at the emergency room. Most people. Some people like the emergency room as often. Just think, and this is something that comes into the area, you know, in Oregon and many places, there's a move to integrate mental health and physical health care together so that the same people are thinking about how to maximize their resources and get the best outcomes for people. What if you have a person who has recurring psychosis, and with proper supports you can keep them, rather than going to the emergency room 3 times a year, you can have them go 2 times a year. Think about the cost savings there, as well as the fact that that person gets to keep their job, they can stay in their housing, they can keep their community natural supports. It's a fantastic savings, and so these principles went forward. And so just some basic things about the Affordable Care Act. These are some of the regulations under it, but the reason I listed them is because in the areas of that we all know, I think, hey, you can't exclude people for pre-existing conditions. Well, you know who a lot of those people were? My clients. And now we're 5 minutes out. So, one of the areas that was included in the ACA was parity of mental health and substance abuse benefits, and the recognition, you know, that they were absolutely essential to addressing in order to keep people healthy across the board. Mental health services were less than 10 years before had been optional services under state Medicaid plans, and this is a big change. In private insurance coverage under the ACA, policies that are sold under ACA have to have 10 areas of coverage: mental health and substance abuse disorder services. And here's a little word that a lot of people don't know: habilitative services. Not only rehabilitative services, but habilitative services. For us we in the disability world, we know what habilitative services are, because social services for people with disabilities, the aged population, and people with brain injury. Habilitative services are key services for people that are not about getting better after an injury, but they're about sustaining and maintaining functionality. When you have a disability, it's most likely going to be lifelong. Huge development. And I went to the meeting in Oregon in which we talked about all this, and I was one of about 4 people in the room who even knew what the word meant. So this is part of the sea change that's occurring right now. In Oregon, I would be happy during the reception to talk about all the things that go into this massive change, but suffice it to say that our governor, who managed to serve 8 years, go on vacation and come back and get elected again twice, he had a very ambitious plan, and the plan was not only to change mental health coverage in Oregon, but to completely transform the entire way that health services are being provided in Oregon. The entire healthcare delivery structure. That's his ambition, so stated. The fundamental basis of it is the coordinated care model, and again, the essence of the coordinated care model, it is not supposed to be managed care as we know it. It is supposed to be a model that integrates social services and health services and measures and funds them and rewards them financially according to public health outcome data, measuring public health outcome data, and then rewarding improvements in public health care data. It's a huge change. By the same token, and again, I'm going to have to whip through this, but there have been a number of ways in which public policy has been affected by the Olmsted decision, that integration decision. And so what you see coming out of CMS now in the areas of long-term care and supports and community are all fundamentally based upon community integration. CMS has just required every state to write transition plans to show how they are going to use their Medicaid money to get people out of isolated care settings and into the community, and will fund accordingly. This is huge. There have also been, in terms of that physical access that we were talking about, just getting on the examining table, there have now been much more refined rules about that, because it was left pretty vague for quite a long time. Even though it was recognized as being covered under the disability laws, there wasn't a lot of direction, and now we have some. One of the very fascinating areas that we're right in the middle of fighting right now is about coverage for applied behavioral analysis treatment for autism. It's a controversial area. It's controversial in the disability community. Some people are seeing it as being too intrusive. Some people think it's absolutely necessary. Some people even think it can cure autism. There's a wide range of opinion. But one thing is for sure is that it has been systematically excluded from insurance coverage, despite growing evidence that it is effective for some people. And this has been the focus of legislation. It has been the focus of coverage mandates, as in Oregon, and in litigation, and it is consistently, when it gets to federal court, the autism advocates win. So it is, and right now in Oregon, we're in the midst of our insurance division creating guidances for coverage. And let's just say if you were working for an insurance company in Oregon, you'd be very unhappy right now about where this is going. But again, I would say it reflects a perspective of let's bring disability coverage supports into our broader healthcare coverage arena, transforming over time the idea of healthcare, broadening the idea of healthcare and insurance for it. There have been a variety of ethical issues attached to this as well. And so since I'm done, I'm not going to talk about those, but I know Professor Mehlman's very interested in bioethics. And so I was going to hit on a few of those. And that's what I have to say today. And now I understand that we have some time for questions. And if anyone has questions, raise your hand and I will try to answer them or throw them back at you. Yeah.
Well, since you took the 1997 article as your template for this talk, and then you brought it forward to today with the ACA and the integration of ACA into Oregon health law, so you have federal, state integration. Now there's, with the results of the new election and the discussions about dismantling of the ACA coming up again, so you've got a healthcare system that's now integrating this law. What's going to happen if it's dismantled?
Well, I don't know what's going to happen if it's dismantled, but I can say that I call me a Pollyanna, but I think that while one of the parties has spent a lot of time addressing the public desire not to be told what to do, which I understand well, that the cost factors are still out there. And I think that party is going to be interested in the nation being economically competitive internationally. So I think that the cost factors are going to have to be addressed. I think a lot of the movements that are occurring within the CMS and in public agencies are discovering through implementation of some of these factors that those factors are popular. They are meeting public desire for those public services, and that much like having your kid on your insurance longer, that there's going to be features that are in the ACA that are going to survive, even if there's a direct onslaught on the law. So I'm not expecting it all to go away, but we'll just have to wait and see.
You suggested in the Oregon model that, relatively speaking, insurers are possibly a loser of the different interest groups. Can you please expand upon the role of different groups in their input in the Oregon model, and who is, if this really is a model for something national, and which groups are quote, winners versus possibly losing certain powers?
Okay, thank you. The politics behind it, of course, is that everybody's a winner. But one of the things about Oregon is that it's a good place for experimentation because it's pretty small. I mean, there's 3.5 million people in Oregon, and there is a type of collective approach to problems, even though there are interests. And so, for example, these CCOs that I were talking about, they're all nonprofits that were created expressly for this purpose. There was an intentional effort made to keep out national traditional managed care providers. So you could say that we're parochial, but the idea was that this is a based approach for this particular state, and the hospitals, the insurance companies, the professional organizations, as well as community organizations, were all brought to the table for the purpose of working the problem. I think that Governor Kitzhaber, probably his greatest value here was being able to do that, being able to articulate the effort in ways that the different groups understood, and also to comfort, or at least say, this isn't going to happen overnight. This is going to be a slow adjustment. It's going to take time and work out over literally decades. And so we have to go at it piece by piece. It's not like everybody loves this, but there really has been broad-based buy-in. And one of the things about Oregon is that nothing happens without a work group. Anybody can show up. If you come to Oregon, I guarantee you the next day you're there, you could go to a work group, you can go to a committee, you can sit at the table, and you can say your piece, and you will be heard. It's quite an open state in that way. One of the things that I like to say, one of the things about Oregon is that this is a state made up of pioneers who were primarily farmers. They are open to innovation. But they don't want to pay for it. So if you can convince people that we're going to save money or we're going to limit money, that's the sell in Oregon, as long as there's robust community involvement.
We're going to let that be our final comment. We have a reception following, and I want to take care.
We have some things for you. Please join us outside for a reception, and thank you all for coming, and drive safely.